Okay, so we know it's been a long day. So this is the final, not panel, but presentation of the not so final, but relatively final outcome of the TRICI-Law project. And the idea was to basically have an open discussion about this. We wanted to use the term roundtable, but clearly, as you can see, the logistics do not make it a round table. An amphitheatric construct, perhaps. So what we'll do is basically we'll present. We have Dr. Nina Mileva, Miss for just a few more days, and then Dr. Marina Fortuna and Dr. Lekkas, who are the essential parts of the TRICI-Law team. I'm here just for show and to make the introductions. So we've come based on the research, based on previous events, and of course, we're going to be blatantly abusing all the new information that we learn these couple of days from this conference as well. Some which we named articles on the interpretation of customary international law. Perhaps this is the first question that we might need your feedback on, whether we should go for articles, guidelines, guiding principles, conclusions, what have you. And the idea is that we try to distill the rules, patterns, methods, again another topic to be discussed, of interpretation of customary international law into something that could be easily readable, easily accessible, but could at least also give quite a bit of information about the evidence that we found with respect to this. Now, please, during the presentations, we'll try and present two articles together, and then we'll stop, and we'd like to have your feedback. We want this to be not as much as a presentation, but an honest conversation so that we can get feedback from you. We've already had quite a few indications from previous panels, but feel free to completely disagree, suggest alternate methods or things that we got wrong or different ways to phrase things. So without further ado, Dr. Mileva.
Thank you, Panos, and thank you everyone for bearing with us.
Sorry.
Yes?
Sorry to interrupt. For housekeeping rules, because there's going to be, there is a demonstration for Palestine happening outside, I need to inform you that we'll try and finish at 10 minutes to 6. Yeah? Yeah, so 10 minutes to 6 so that we have enough time to gather our stuff, and we'll exit from the side entrance. If you don't know where the side entrance is, spot a Greek person and follow them. It's very close by. Yeah. Yeah. We can use the tote bags as blankets. It's fine. Yeah. And since we're doing these housekeeping, also for chairs, speakers, organizers, supporting staff, afterwards there's going to be dinner at the Aleria restaurant. There is maps at the back of the booklet at 7:30. It is, I think, about a 10-minute drive by cab from your respective hotels. If you want to walk, of course, by all means. But that's it. So Article 1 and 2. Sorry for interrupting.
Thank you, Panos. And then in the interest of time, I'll try to go through my comments very quickly so that we can hear more from you. As you can see on the screen, and as that was shared with you also in anticipation of the conference, Article 1 says that rules of customary international law are subject to interpretation. And this is one of our introductory provisions that essentially is based on the findings that arguments against the interpretability of customary law are not persuasive and do not find support in the practice of states, national or international courts. I will very briefly talk about the two main objections to interpretability that we have encountered in the work of the TRICI-Law project. The first one being, well, you cannot interpret unwritten rules. The second one being, interpretation always refers back to elements and therefore collapses with identification. So there is no interpretation as a separate exercise. With respect to the first objection that you cannot interpret customary rules, as Panos spoke briefly this morning, in the practice of international law, in fact, we have ample evidence and we have the acceptance that other forms of unwritten rules or acts can be interpreted. And this on its own already tells us that there is no principled objection to the interpretation of unwritten entities. Furthermore, the practice of both national and international courts consistently rejects this objection because, in fact, in the work of the TRICI-Law project, we found a lot of evidence, and my colleagues will talk about this more when they talk about the methods, but we saw a lot of evidence of both international and national courts interpreting customary rules. Finally, the objection from the perspective of theory that customary rules are wordless or sine lateris is similarly unpersuasive in the sense that customary international law is not only a collection of practices, but it is also the textual or the linguistic expression of the rule. Moreover, from a pragmatic perspective, we always have to express a customary rule in a linguistic or a word-based expression in order to be able to use it. So in sum, all of these things indicate that the unwritten nature of customary rules does not prevent their interpretation. With respect to the objection that interpretation refers back to the two elements and therefore sort of collapses with identification, Sotirios will say more on the distinction between interpretation at the stage of identification and interpretation proper of the customary rule. So I will not go into this. For now, I will simply say that this argument is unpersuasive because, in fact, we see that also in the interpretation of treaties, when we try to identify a treaty, so when we try to establish that a thing is a treaty, there is also some rudimentary interpretation taking place. We are trying to discern whether this thing that we are observing corresponds to the definition of treaties we have. We are trying to discern whether this thing has a discernible intent to be bound. And here we may also have some rudimentary interpretation. But this has never led anyone to conclude that there is not also interpretation proper of the treaty rule itself. So much on the same reasoning, we can say the same for the interpretation of customary rules, that while indeed we may say that there is some interpretive reasoning at the stage of identification, this does not preclude interpretation proper of the customary rule itself. And that's all I will say for now for Article 1, and move briefly to Article 2. Interpretation of customary rules is a holistic exercise. Here, once again, we draw our inspiration from the knowledge we have about the interpretation of treaties. So the language of Article 31 of the VCLT, which is familiar to all of us, speaks of a rule of interpretation rather than rules of interpretation. Already this formulation signals that interpretation is a holistic exercise in the context of treaties. And we have found much the same to be true with respect to customary rules. So what we see in the practice both of international and of national courts is that when they interpret customary rules, and this concerns both customary international rules and customary rules in the particular domestic system where relevant, they engage in this in a holistic manner. And what I mean here is that they look at the text or the ordinary meaning of the words of the customary rule, they look at the object and purpose of the customary rule, they look at the overall context in which the customary rule emerged, etc. So we see very much the similar pattern that interpretation is a holistic exercise in their interpretation of customary rules as well. Thank you.
Hello. Because
so are there any comments? Yeah.
Yeah, thank you. Thank you very much, Andreas Kulik. Thank you for this for the invitation to this conference and to this really great project. Panos, I think I don't have to tell you that I'm very sympathetic to all this. A brief comment on the holistic exercise. And you said it's open to how to call these articles or guidelines or whatever. But as I understand, your intention is that it also plays a role, or should play a role, ideally in practice. Practitioners pick it up, maybe to some extent. Therefore, my recommendation would be not to call it a holistic exercise. Yeah? Just because, I mean, it's, of course, from an academic point of view, yeah, it's the precise term. But I think, if you adapt, for example, the language that the court is using, single combined exercise or something like that. I mean, you're expressing the same thing, yeah. But I think you there might be a risk, you losing part of the audience by using this a bit of a wonkish academic term in the beginning. Yeah?
Wonkish, it's Greek.
Yeah, and I'm saying that because I'm using those terms also, but I think you do yourself a disservice that is not necessary in my opinion. Yeah? And maybe just briefly also on the interpretability, I'm completely sympathetic to that. I was always also listening to, reading your various articles on, that you can also interpret unwritten rules, and also hearing that, sometimes I feel a little bit like, is it really necessary to defend it that much? Because to my extent, in my opinion, I think it's so obvious, also as a lawyer, that also in domestic law, you're trained in the beginning, or you can conclude a contract, whether it's written or unwritten form, and then of course you have to interpret it. So, and the philosophy of language, as it was pointed out, it's so clear that eventually we also always, in order to make sense of things, we have to express it in verbal form, at least. If it's not written, then at least in verbal form. And then of course we can interpret it. So, there's just a question, maybe, again, if you're pounding that point too much, it seems maybe not necessary to the extent that you're pounding it. It's just an impression.
Actually, I would like to agree with Andreas about this holistic. We love this word, I know, but very many times my friends who are barristers and solicitors, they were asking me, what is it with you people and this holistic? What really does it mean? Could you just not have it? So I fully agree. The other comment is, it's kind of really free fall thought, what I have, but all the conclusions of the International Law Commission, which were filling gaps in the Vienna Convention, so my favorite subsequent practice and agreement, use cogens, customary law, in some, introduction they were referring to VCLT as it is. Maybe it would be a good idea to refer generally to VCLT and how do you use it, whether you use it or not, or whether you acknowledge some of the principle of interpretation. I think that it would make sort of good introduction that is somewhat related to well-known international law and would put people at ease that it's somewhat, has roots in something they know. Okay, thank you.
Any other thoughts?
Yes, a little bit of a drafting issue. You start with Article 1 on interpretability, which I understand, and you've done a lot of work in trying to establish that actually there is interpretation going on. But your second objective of the project was to say that it might be subject to rules of interpretation or principles of interpretation or this or that. And I think that should be reflected as well, I would say, in Article 1. So are subject to interpretation and are governed by the following or something like that. So basically you're setting out, I think, after Article 1 a number of either principles or this or guidelines or whatever, but you should kind of make that clear, that it's not just the factual interpretation that you're aiming at, but actually at a kind of regulation of it. Leaving aside whether we can really, I don't think we can establish already, that there are specific rules, You formulated these and we'll have to see how that impacts on our scholarship and maybe eventually on the positions of states, but I don't think we're there yet.
Thank you. I'll agree with Andreas. I had also highlighted in yellow as I was looking at these articles. Now, about referring to VCLT, right, within, the articles themselves or whatever they're going to be called, because I see it's noted in any case in the commentary of Article 1, the first sentence. I would be hesitant in, a priori and right from the beginning, sort sort of saying that we're going to be applying this, you know, because it looks to me, having looked at not the commentaries, but the draft articles as a whole, when you sent them, that you're reaching that, you're asking yourself, and these guidelines are sort of, you know, following a method to see whether, you know, and how VCLT would fit in. And I mean, I think, you know, maybe identifying VCLT there and just might stick out in sort of an unfavorable way. So I'm not sure I would agree with Malgosia on that specific topic, even though we agree on everything else in life. So that was yes, I would use for holistic, I would use what the commission used, something like that. I'm also not comfortable with the word interpretability, to be honest. And generally, I'm not even sure you need Article 1, but that's a different issue. At the end, I'll reserve that for the end.
Thank you. Okay, yes, so on Article 1, the way I understand it, the reason why it's there is because there are still a lot of scholars who contest the possibility of customary international rules being interpreted. I completely get the fact that it gives out a defensive signal. It is sort of the premise for everything that follows. So maybe there can be a middle way of having an introduction part where you can have all this, even the reference to VCLT and this interpretability question without necessarily having an article specifically dedicated to this. I had another point on paragraph 3 of Article 2. The first part does not really concern customary international law. When you say, as in the case of treaty interpretation, there you're stipulating something that concerns treaty interpretation. So to me, again, it's just to show that you're basing yourself on the VCLT. I think this is what I get from, at least this is what I get from reading it. But textually, it goes beyond the scope of this project. So I would suggest deleting that specific introductory part of paragraph 3. Thank you.
Hi. It is obvious that I am suffering from some sort of PTSD from doing that exact thing 8 years ago for the shared responsibility project. And as you know, Panos, you have a kid now and you realize that kids and adults don't listen to advice. Yeah, they do what you do. So, but I wanted to say two things. I hear the conversation going on about drafting this, drafting that, using this and using that. I would think my experience, and I can only talk about my experience in a different project under different circumstances, is that part of the project took 4 years to complete after the 5 years of the duration of the project, right? So I would say that it's good to take stock and listen to what people have to say, and it's very useful at this stage. You did well on that. Second, don't expect too much too soon from that. It's frustrating. Trying to draft something is really frustrating. And the third point is, I would take an issue with calling these articles. Yeah. I think it doesn't do justice to what you do, not because it is too pretentious, but because it takes away the generality and the way that you expect people to use them. Someone is like a practitioner or a judge even, right? Might find it easier to use a guideline or a principle or a guiding principle or what have you than an article. Article gives a very rigid sort of image, brings up a rigid image on someone's mind, this is what at least we understood. Yeah, I just wanted to say these things and let you go on with the presentation. Thank you.
It will take some time for me.
Thank you very much. I should sit down. I will not repeat what has been said, just share my impressions. First, I agree that the, guidelines would, in my view, be a better name. Second, there should be a preamble where you can make a certain number of statements without them being prescriptive ones. And there, this is my feeling regarding Article 1. I'm not comfortable with it because you just make prescriptive statement are subject to interpretation, and then you will have people saying no, and then. Whereas in the preamble, you can say that the approach of the guidelines is based on the assumption that rules of customary international are subject to interpretation, and that's it. I have no problem with calling it holistic exercise because I mean, some judges do it themselves. They say it is a holistic exercise. So, but I take the point made by Malgosia. It's a choice to be made by you. Whether again you should put it in the title and repeat it in paragraph 1, or just have it as the title and having paragraphs 2 and 3 being explanatory of the title. Not sure it's useful to repeat it again as a prescriptive statement. I'm not sure. And I also agree about the idea of removing, as in the case of treaty interpretation, because you are looking for guidelines which are self-standing. So I mean, it's uncomfortable, in my view, to look that you draw from the VCLT can be said in the preamble because they are there, and even when the International Court of Justice interpreted the unilateral declaration, it made the exercise of saying let's look at what the Vienna Convention says and let's explain how and why it departs from the Vienna Convention. So it plays as a reference, inevitable reference, but indeed the preamble could be enough, or the commentary could be enough to say it. Guidelines, and again, you state rules on principles, on methods. I have no strong feeling there. I know that it's a toolbox, and it's a word which is often used by people working on interpretation. And so whether you should call them rules, I think sometimes it's misleading to speak of rules, because it's more, I think of them more as tools. So I prefer either principles or methods as a name to rules. It's a subjective feeling.
Hi, I also want to voice my support for certain elements because, at least it was my experience in the ILC, it's important to know how many people are in favor, of any proposed amendment, even though it has already been mentioned. So I also I voice my support against the inclusion of Article 1. I think it could be part of the introduction of the project. In my view, it would be good if you had two introductions, one introduction of the entire project and then preamble and introduction to that, because that's how I perceive it, at least. You have some introductory remarks you want to make over here. Perhaps I can identify some both in definitely Article 1 and perhaps also from Article 2, introductory to the entire project, and then you could have a preamble, as was rightly mentioned in my view, and have a second introduction. I think it could help you, it could benefit a lot. But yeah, again, Article 1, yeah, it seems also a bit defensive to me, I agree. I think you should take it for granted, or at least if you want to engage into this, just in the very, very, very early introduction, dismiss any claims to the opposite. But I think as long as you start with the preamble, this is taken for granted. If someone opposes this one, she or he should not even open the document, it's fine. And then also, yes, about the articles thing, I also concur with the view in favor of guidelines it seems to me more appropriate in this sense. And then about methods and rules, perhaps this needs requires careful thought because you will have to see how you will qualify textual interpretation or by proxy, as you called it, the principle of stemming integration. If you call them principles, perhaps you might have, you might stumble over this issue. Like all of them, you have principles, and suddenly there is the principle of stemming integration, and the other is by proxy textual interpretation, even though it seems that there is no hierarchy, so they should be qualified with the same term. That's how I view it. And again, there is one more point. I think I missed it, but I will get back to you.
I agree with many of the things that have been said. I just wanted to maybe come back to Article 1 and what the scope of those of this exercise actually, because some of the articles principles are really about the methods of interpretation, and but for instance Article 1 and Article 3 are about the scope of the exercise. So I could see maybe if you merge Article 1 and 3 in a sort of like setting the stage. So those methods are about the exercise of interpretation, and we differentiate interpretation for identification, and then you have the sort of prescriptive part with the methods. And that, for me, it would work then to have an Article 1 where you say, well, given that rules of customary international law can be interpreted, the object of those articles or principles is actually interpretation, not identification.
I just recall because you mentioned scope. Sorry, and again, yeah, that would be my suggestion. You need, I think it would be good to have the first one scope, or even a second one like a purpose. And in this context, yeah, you could definitely do away with Article 1. And regarding Article 3, I know you haven't showed this one. For me, it could also be a preambular clause, taking into account that there is a distinction between identification and interpretation, and then you include these analysis and the paragraphs of Article 3 within this one. I think you should take it for granted.
Just very briefly on the point, whether to call it articles or guidelines or whatever, I wanted to contest a little bit what has been said. I think you can, in my opinion, you can use articles. I mean, I think you can be confident. Of course, there's the risk of sounding a little bit pretentious, but I think, I mean, you want to have it for it to have an impact. But I think the question is then more, I mean, if you really call it articles, yeah, then it has to have kind of this codificatory gravitas. Yeah? And the way it looks currently, it seems be a bit of a mixture of both. Of the more guideline approach, if you look at Article 3, paragraph 1, for example, that's quite a guideline. I mean, that's not really a codification. Yeah? Some others more look like that. So I think you, when you choose what it's going to be, then you should also choose the way you present it, in my opinion. And I wouldn't have a problem with calling it articles and being confident about it, also because you're using in that way, the ILC approach. You're having a commentary as well. Yeah? So then you're open in what you're doing, which I think is good. Yeah? But I think it is about the framing, how you frame it. Currently, it feels like it's different styles, yeah? And they don't really know exactly what they are. That's how it looks a bit to me.
Actually, quick comment on Article 2.3. As in the case of treaty interpretation, there can be overlap between the various, etc. I just quickly looked at these articles 4 to 9, and they actually combine principle of VCLT with evolutionary interpretation, effectiveness. So I think that it is a very general article, and maybe at first blush it could look like you only refer to the Vienna Convention, but you go beyond the Vienna Convention. And I think that it should be indicated somehow that these methods are not only VCLT, but you sort of treaty interpretation, you look into other avenues of treaty interpretation which were not provided for by the Vienna Convention. In my view, it's a bit too general, I think, and may give an impression that you talk about VCLT only. So I think that it has to be probably redrafted to be more precise what you mean in this case of treaty interpretation and overlap. Thank you.
Thank you. Short comments. First of all, congratulations for the work you have made. Regarding the title of the work, I think that draft article is not the most accurate title for several reasons. Some other participant has made some comments regarding to that. I think that the document is more kind of guidelines or conclusions, but it's true that conclusions. I'm thinking at the method of work of the ILC. Conclusions is not the most adequate word, in particular because you have speaking on principle, Probably there is a possibility is to the title could be draft principles on the interpretation. Like that, you can keep the normative dimension of the work, but without use the word articles, because when you use the word articles, you are given you are offering to the other people the idea that you are making some new proposal. That is the use of the word draft articles in the ILC. So I think that principles, I'm thinking in PERAC is a good, could be a good option. On the other hand, including commentaries to this kind of documents, and in the documents of the Commission, the products of the Commission is very useful. You can add commentaries in draft articles, draft commentaries, draft principles. So that's the first one. Regarding the Article 1, I agree about the comment from Celine. I think that Article 1 and Article 3 could be drafted again together. Because at the end of the day, they contain the idea what is the purpose of the work, and first of all, you avoid the defensive nature of Article 1, but you can maintain that. You keep that as paragraph 1, and finally, regarding the use of rules and methods. Well, we are in the same situation that regarding articles or conclusion guidelines. I think that if you intend to keep the use of the word principle, the wording principle of systemic integration, principle of effectiveness, is very difficult to include, to keep only the word method. Because I think that one principle is more than only a method, is a rule governing the interpretation. So I think that it could be possible to use rules and methods in the same vein that the ICJ usually speak about rules and principles. That's all. Thank you.
Thank you. So far, no comments yet on Article 2, Paragraph 2, so let me repeat. I don't like the crucible approach. I don't like the idea that you say that all elements of interpretation have the same kind of bearing on the issue of interpretation. But more particularly, Panos, I know you like to go off on a rant about systemic interpretation and how it's wrongly interpreted in Vattenfall and biotech and that kind of thing. But unless you actually apply some kind of weightings to the elements of interpretation, you simply cannot conclude to misinterpretation or transgression of interpretation into modification. You need to have some limits to how you use the elements of interpretation to actually see the limits of interpretation and the possibility that something is a misinterpretation, an abusive interpretation, or modification.
So thank you. Let's move to the next articles then. Actually, I prepared some slides. I don't know whether we would put Article 3. It's fine. Let's start with that. So the purpose of this article, obviously, is to go more into the scope and actually integrate our proposal to the actual doctrine of custom. The propositions are first, the distinction between the two operations, right? Which is axiomatic. It's not axiomatic, we prove it. The second is about what is interpretation, what it does. And the third is the delimitation of the gray area, and we are trying to give a guideline as to that. More on the commentary, of course. Let me explain a little bit this thing. Generally, it is easier to see it in treaties. There are certain things here, in the whole project, which, many of you might ask, what is a rule, what is interpretation, and why it relates to custom. So if you take treaties, as Panos said in his presentation, it's quite easy. There is a rule that says what is a treaty when it comes to identification. When you apply this rule, you inevitably, the applier, inevitably, because they are working with the text, make use of interpretative means, and there is an overlap with that. And as Andres said, there is a difference in how much weight we accord to these interpretative means. Why? Because identification has one purpose, which is the establishment of consent of each of the parties to that instrument, that it is a treaty, right? That they want to be bound by it. Whereas interpretation, again, in the context of treaties, it is based on a rule or rules. There is the use of means that look very much, like the ones that we use in identification. So there is an area of overlap there, but it is clear that the rule, again, puts emphasis on certain means over others. So the very purpose of Article 31 and 32, the way that it is configured, the Vienna Convention, is to say this is the rule and these are the supplementary means. Why? Because interpretation has a different purpose. It is to establish an intersubjective meaning of this thing, right? Not what each of the parties thought, whether each of them wanted to be bound, but what it means, an intersubjective meaning. So the same thing happens with respect to unilateral acts. Okay? Again, pretty much it's the same thing. There is a rule of identification, custom. This rule may entail the use of means that come close to interpretation. There is an overlap there. There are methodological differences. Why? Because there is a difference in the actual purpose of this exercise. In the first place, it is to find whether this unilateral act is binding, and there it is important to understand whether the declaring state actually wanted to be bound by this declaration, whereas in the second stage of interpretation, the aim of interpretation, again, is intersubjective. Okay, it is intersubjective because this state became bound towards someone. And the same translates into the law of custom, in a way. Here I have all the things about the approach of the ILC. Again, in short, the ILC, what does it do at its core? It introduces certain articles that it believes are rules. There is a normative approach to custom. This, to identify custom, you need to apply certain rules. Okay? Again, in applying certain rules, you might use interpretive methods, like in understanding whether a piece of verbal state practice, for instance, is accompanied by opinio juris. You interpret it. You look at the text, you look at many things. But this might be rarely spelled out. Sometimes it is spelled out. But again, all of those things are, a must. There is during the process of interpretation, all of those interpretive means are used indistinctly. There is no order. Circumstances, bravo, when you look at whether a treaty rule also reflects a rule of custom, you take all the means of interpretation distinctly. Negotiations, subsequent practice, everything is the same. Whereas, and this is what we actually are trying to say, this is because the identification has this purpose, again, to establish whether each individual state doing the practice, has consented to the formation of custom. Whereas the rule of interpretation, again, has a different aim, the intersubjective meaning of the rule of customary international law. Actually, the ILC itself has suggested that the identification of custom entails deduction, right? So, the paradoxical implication of that is that if you take it like that on face value, that custom, actually, these are rules of identification, is that rules of customary international law can be created by partition, like living beings, like amoebas. You have one, and they start, dividing, right? But this doesn't make sense legally, because where is here the principle of consent, right? So I hope we now understand what we mean by this distinction and why we thought this article is important. And then by textual interpretation. Identification of custom very, very often, although it is in principle an inductive operation, very often for us we need to establish first a hypothesis. Which hypothesis in practice? It's not like we take a treaty provision, we see whether there is state practice, and you look at all the circumstances, and then you say, okay, this reflects something, this reflects custom. You take an ILC article, you take a dictum from the ICJ, there is something like that. The basic idea here is you have a hypothesis and an inductive way to prove that this proposition is custom. So, in principle, custom remains unwritten. So you cannot apply a textual approach to custom. However, if the interpreter has done this, has taken this hypothesis from something, from a text, from an instrument, and has established that this instrument reflects general practice accepted as law, then they can proceed with the use of textual interpretation. And in practice, what does it mean? Ordinary meaning. The ICJ did it in Gabchikova and Maros. It tries to establish what the word peril in Article 33 back then of the ILC articles was necessity. Grammatical approach. Prime example, Article 8 of the RC1. Instructions, directions, or control have commas between them. So these are three different rules. But really, they're custom though. And the culmination of it, and that's why we have it in the article, is this utres magis valeat quampereat. You take a text, and then you are saying, first, within the proposition, much like what Vaios said, that, you cannot omit certain words merely because you like it. If you determine that a certain proposition actually reflects custom, then every term must have meaning. At the same, here in Devas it was, they look, for instance, the ILC articles of state responsibility, they interpreted them against each other, right? And they use this interpretive principle. Thank you very much.
articles and then gather all questions if we have enough time.
Good evening. I will be very brief so that we can safely leave the space on time. So I will address the next two articles. Firstly, the teleological interpretation of customary rules, and we posit that rules of customary international law can be interpreted teleologically. In treaty interpretation, and here parenthesis, I am just drawing on treaty interpretation to establish a comparison with interpretation of custom. We see that the treaty, the terms of the treaty shall be interpreted in accordance with the ordinary meaning in light of object and purpose. In the case of interpretation of customary international law, the reliance on teleology is self-standing. So the judges, and this is something we derived from practice, from looking at a vast amount of case law, the object and purpose, or the purpose of the rule, the rationale of the rule, the teleology of the rule, essentially pointing to the same thing, is assessed by reference just to the customary rule itself. Now, we see instances of this type of interpretation, especially in the practice of the ICTY, so also the ICC, the ICJ, in dissenting opinions of the ICJ, but also in domestic courts. So in domestic courts, when they interpret the rules on immunities of states. Moving on, I would like to point out that often, again, especially in the practice of the ICTY, a teleological interpretation is taken together with considerations of reasonableness. Unbeknownst to Professor Kotroulis, I was thinking, oh, well, we can tie this, what you said about the reasonable outcome, to interpretation of custom, because the ICTY often refers to logical and teleological, or reasonable and purposive interpretation. And finally here, with regard to teleological interpretation, we see a reference to the teleology of the rule as the reference point in interpretation, or the teleology of the whole branch of law, or the institution of law to which the rule belongs to, which essentially is a combination between teleological and systemic interpretation. I will now move on to the next conclusion, so next article, which pertains to evolutive interpretation. Again, here we posit that rules of customary international law can be interpreted evolutively. As Professor Fitzmaurice noted in her presentation, in treaty interpretation, the possibility of evolutive interpretation rests on elements such as the use of generic terms or the nature of the treaty. With custom is slightly trickier. However, we have found evidence that evolutive interpretation can be based on factual developments. Equally, it can be based on subsequent practice. However, here there may be an issue of how to draw the difference between evolutive interpretation and modification of the customary rule. And of course, evolutive interpretation can also be based on developments of the law. Here, an interesting trend we noticed in the case law is that reliance is made to emerging trends. So, for example, in the practice of the ICJ, it has been stated that emerging trends in the law can be used as an aid in the exercise of interpretation. Yeah, okay, now I give the floor to Panos. No?
I think it is best if we gather questions and then we figure out what we do with the other articles. Yeah.
Yeah, thank you very much, and I'm aware that we have apparently only 3 minutes, so excuse my kind of staccato style comment. So on Article 3, Paragraph 2, you say that interpretation of custom focuses on content determination, and I mean, call me German and terror splitting, but to me that includes also the clarification of meaning. And I think there should be, I mean, I haven't read the commentary, unfortunately, so that was a little bit confusing to me. The next is Article 4, Paragraph 1. I would actually not include that. I think that is something that should be included in the commentary. I think it is clear that you know, it's an unwritten rule, so textual interpretation, stricto sensu, doesn't apply. But if you put it in that article, it is confusing because, I mean, you, as has been mentioned many times, you will always have kind of a lexical garment, and then again, it is to some extent textual. So I think it's doing more of a disservice mentioning there, and it can be included in the commentary, in my opinion. And then also the by proxy textual interpretation. To me, it feels like if you have an authoritative text, then you interpret it according to the rules that the text has. Treaty text is treated according to the Vienna Convention on the Law of Treaties. I think the question is then more, why does it have that authority, and how does it relate to other interpretive material? And then I was also a bit confused, I have to say, by paragraph 4 of Article 4. I said great care and methodological rigor needs to be exercised. Well, that always needs to be exercised anyway, and to observe the limits that are in Article 10, which I guess we cannot discuss anymore. But I mean, if you mention it only there, it is a bit confusing because the same applies to Article 5, Article 6, Article 7. So either you have to mention it in all of them, or I think it's just self-evident in Article 10.
I think we may have been triggered by Colombia and Nicaragua on this as well.
Yeah, but I find it more confusing, actually. And last word on the teleological interpretation. I agree that there has to be something of an object and purpose of the customary rule, and also the branch and purpose of the law. But then the question obviously arises: where can we actually draw any line there for a court or tribunal not to run completely wild with it? Because it is different to a treaty provision or the overall regime of a treaty, because it is precisely not written. So it's just, maybe it's addressed in the commentary, but.
I have a really very small comment also with by proxy, because if we have exactly the customary rule in the treaties, we actually, according to Nicaragua rule, this is the same rule but from a different source. So I would say that if it is in treaty, we should really apply the provisions of, Article 31, because we interpret a treaty, not customary law. So I think that it is a bit of confusion. How do we interpret customary rule which is codified in a treaty? I think when the court sits and interprets a treaty with customary norm, it looks at a treaty, doesn't, look exactly at customary norm. That's what I think.
Yeah, the reason why we focus on the by proxy kind of thing is that if we take out the by proxy, then you go in textual interpretation, then you have all these other arguments. Oh, you can't textually interpret customary international law. And just because the courts look at codificatory instruments or treaties, because they cannot apply them, they cannot interpret them. So there it is simply a reflection of what they believe. And that's why we want to make sure that there is a clear distinction, that this is not the exact same thing in the Vienna Convention there.
Yeah.
Otherwise we open ourselves.
Be clearer, maybe.
Yeah, fair.
Yeah. Okay, thank you.
Okay, we'll be quick. In a way to combine Article 10 and the rest, perhaps if you had the first one on scope, and then it could be like this outcome, the outcome document will elaborate or will outline the rules or the means or the methods of interpretation of customary international law, subject to the applicable limits, and then this will cover all principles or rules or how you will end up calling them, and then in Article 10 you could just omit the first paragraph and directly go into the limits. Just a suggestion.
Very briefly, to two comments. One is like this theological interpretation. I'm not going to go into that again, but for me, when I was reading when I was reading the articles, the draft articles, I thought that actually the part on by proxy is a complement of the theological kind of interpretation. So it would make more sense for me to have first Article 5 and then the by proxy eventually, if you want to maintain the by proxy interpretation. And then it's just an issue of language. You put everywhere can interpret or can rely, and that is what is your ambition with these rules? What is your normative ambition? I was expecting a more kind of a hard kind of language, like at least a should, should rely, should interpret, and not a can, because then of course it's can, but it can also not. So what is the alternative?
I take the point of not being able to interpret textually stricto sensu, but of course you've been making arguments on textual interpretation lato sensu. So, you know, the lexical, the linguistic expression of the rule is possible. The question whether that is the goal of the process of interpretation or whether it's an element of interpretation, well, that's something you can debate. The second point, you're completely ignoring context. And context is important. Maybe you want to subsume it under systemic integration, but if you take the example of direct participation in hostilities, that is linked to two other rules, which is the protection of civilians and the rules on targeting. That again is then connected to the principle of distinction, etc., etc., etc. I think, I know, but context is the first element you use to limit the frame of interpretations. A hot car is only, you know, a hot car because it's stolen. A hot guy is hot because he's sexy. Context is the first element you use to limit the number of interpretations possible.
I'm sorry. Well, this Article 6, okay, evolutive interpretation. It's a very general and broad article. I think that to put rules of customary international law can be interpreted evolutively. It's such a, you know, still a point of discord and point of debate. So maybe under certain circumstances, some qualification could be, you know, I think could serve the purpose of saying that it's not just a general permission to interpret evolutively, but it has to be within certain parameters. Thank you.
I think we ran out of time, so that all can leave safely. So thank you very much for this. We will kindly ask to abuse your kindness a little bit more, because we blame panel 2 for taking so much time. If you have the ability, either tomorrow or in the days following the conference, to go through the articles and read the commentaries, we would really, really appreciate it, because we do find all these comments very useful in streamlining this and to making it something useful. If you have the time, we would very much appreciate if you could send us your comments and then try and combine everything with which, like in the case of the ILC, everybody's very unhappy, but it is the best that could be done. So thank you very much for this, and hopefully we can continue the conversation. Good luck with leaving safely, and we'll meet with most of you at Aleria, probably, and tomorrow.